May I please your lordship? Lordship, I beg to mention, I filed already one IA in connection with item number 6 of today's list. The record may kindly be called for today and hear the matter today. IA, I thought.
IA for what?
Obliged.
IA for what?
IA in WPC, lordship,
For what?
for implement of one party. Obliged.
May I please your lordship? Lordship, with the consent of the other parties, my lord, I beg to mention item number 4, lordship. Matter may be kindly after petition. lordship.
Adjourn.
Possibly only the date may kindly be fixed because the senior advocate for the.
Whatever date you ask.
Oh, yes, okay.
8 January.
No, 8 January, not that. So will not be
Sorry.
available on 8.
Next, please.
10th.
Yes.
Lordship, beg to mention item number 7, Lordship. I've taken from consent from the other side, Lordship. In this case, Lordship, I am led by Mr. Ken Chaudhary, Senior Counsel. He's out of station today. May I pray that this matter be taken up day after tomorrow?
Challenge the validity of some provision.
Lordship, I challenge the validity of the scheme.
And then it will come in January. Yes, next.
My lord, I beg to mention item number 22, my lord. I may be permitted to withdraw the
22.
22.
Writ petition.
My lord, writ appeal.
That 45 lakhs.
My lord, I may be permitted to withdraw. my lord.
Wants to withdraw, dismiss as withdrawn. You are for the appellant.
My lord,
Yes.
May I please, Your Lord? So, Lordship, item number 18, Lordship. Item number 18, Lordship. Lordship, there is an interim order, Lordship, and we have taken steps, Lordship, and tell it. Lord, perhaps my friend has not been filed a reply. And my lord, interim order may be continued.
Who has not filed it?
Respondent number,
Whether they are in requirement of filing and reply or not. They are willing to file reply.
yes, Lordship.
Let the number comes, we'll see. Let
Lordship,
the number comes. Wait for your turn. Yes, ma'am.
May I please your lordship, with a joint prayer with regard to item number 19, lordship. Joint prayer both by appellant as well as respondent, lordship. Respondent number 1, after view vacation.
Interim order is there.
Already, IA is, yes, interim order is there.
There, lordship.
Is there.
May be extended,
The
lordship.
request of the concept of the, you are for the respondent.
Yes, both joint prayer.
Joint
lordship.
prayer,
Joint.
lordship.
The request of the concept of the parties, list after leave vacation, interim order, if any, to continue till next.
Date may be fixed, lordship.
Deep prayer.
Much.
Hey, please, your lordship. And mentioning for the listing of our matter millets, we have filed an IA for early hearing in a
Next week,
PI.
like, next. Up to January में January में
Well, as there's an interim operating against us, there's an interim order operating against us. We have filed an IA for early hearing. Maybe taken up any.
Wednesday.
May it please your lordship, with regards to item number 29, my lord, I have taken the consent of the learned counsel of the respondent. Also, I am praying for an adjournment as my learned senior is having some personal difficulty, my lord. Let it be listed after due vacation, my lord.
adjourn.
With this lordship, also praying for adjournment of item number 31, your lord.
31,
31, your lord. With such further adjournment.
adjourn.
May I please your lordship? Lordship, I am appearing on behalf of P. Mohanta for item number 20. Honorable Justice Goswami may not like to take up this matter.
This is the appeal. Please, your lordship, sir.
item number,
Another bench.
item number 25, I'm seeking a week's time because the government has filed an affidavit and I need to get a reply on record, Your Lordship. 2 weeks' time.
That 15 years matter.
Yes, the PIL, yes. I've got the affidavit. I just have to put an affidavit in response to that.
But then now it will come in January only. After
It'll come in January, no problem. Any
the
date convenient to Your
request of
Lordship.
the concept of the list after due vacation.
Grateful.
May it please lordship, I seek your permission to beg mention item number 3.
Who do you want?
Lordship, sir is on medical emergency and sir's name is already reflected in leave note.
This review with this, sorry.
Read appeal.
Yeah, what do you want?
Sir is on medical emergency and sir's name reflected in leave note also. So pass over the matter for today.
Arjun.
May I please, your lordship, with the consent of the other side, I beg to mention item number 28 of today's daily list, my lord. Kindly adjourn the matter for today, my lord, and take up the vacation, my lord.
28.
28, my lord, of the day.
Arjun.
I'm deeply obliged.
Any other request? Daily list for orders item 1.
Functional. The shell is functional.
Yes, ma'am.
Let me.
Copy এটা করে দিল।
Ma'am, now it is functional and they have circulated the address also.
We'll just verify once lordship and let this PL be closed after the vacation, winter vacation. Only the first week, just we'll see how it's accessible and this thing. Just we need to verify once.
The schools have all to register with the portal, put up their details in the portal, and then it will be accessible to, or it will have all the information required.
Okay, Mr. R. Majumdar. I submitted that. The web portal is operational from 30th of December.
December, madam.
30th of December 2024. And the concern officers are directed,
Friday ko hindi.
the concern of officers are directed to send this information to all the inspectors of school, inspector of schools / district, this DEEO,
District Elementary Education Officers.
district elementary education officers of the respective districts with the further direction to ensure the registration of eligible school in the portal for effective implementation of section 12(1) in bracket 1 and in bracket small c of the Right to Education Act. Learned Council has placed on record a communication sent from the Joint Secretary of Government of Assam, Department of School Education. The same is taken on dated 13/12/2024. The same is taken on record. Learned Council appearing for the particular phrase. Some time to verify the above fact. Template for his granted list of the new vacation
Deeply
Right.
obliged.
for admission. List of the new vacation for
Item number 2.
May please, your lordship. Should the I is for delay condonation of 212 days.
ultimately what relief we can grant you now?
Lordship,
What relief now we can grant you? Now the examinations are over, appointments have already been provided. What
Lordship, the-
relief now you want?
Lordship, the thing is that, Lordship, this person, Lordship, if the age is realized, Lordship, the main issue which hinges upon the entire issue.
Whatever it may be, sir, ultimately what relief can be granted? When the selections are already over, the third party rights are already created. How
Lordship,
we
in-
can interfere in this matter and ask them to allow you in this? What about the further stages of examination?
Lordship, the only difficulty would be that Lordship, this person, my Lordship, he can be accommodated because Lordship,
How
this
can
person.
you be accommodated without passing the main examination and the viva was it?
Lordship, that proves. Huh? It already negative. Lordship, on merit, this person had already passed this examinations, Lordship. On merit part, Lordship, that
Now
was been
it's
looked
very
into, Lordship.
difficult. When the seats have already been filled in, is there any seat vacant?
Lordship, there was an interim order passed by the court on the very first occasion, Lordship, when
Okay,
it was
fine,
before.
allowing you to appear in the examination. But what about the vacancy position?
Lordship, on the next examination, if Lordship, on merit, if I could submit, Lordship, that this is a perfect case, Lordship, where the state government came with that objection that no, OBC we have never granted. Lordship, on that count, when Lordship, we obtained this RTI, Lordship,
RTI
all
in
along.
other examinations, certainly it was granted, but in this examination, whether the OBC relaxation was granted?
Lordship, in this matter itself, Lordship, they have given seats to the OBCs, Lordship, but with that affidavit, Lordship, the department did not come up with an affidavit stating that this reason was there. And Lordship, I had informed. Lordship. Lordship, I have instruction, Lordship, that these seats are not filled.
Even though if we allow this condition application, what relief ultimately we can grant?
Lordship, the seats are not
When the
filled.
seats are already
Not
filled in,
filled, not filled, not filled.
how come you know?
Lordship, these three
This
seats, Lordship,
examination is of 2018.
2018, Lordship, 18, Lordship. Lordship,
Thereafter
pursuant to
also
that.
some selections must have to.
No, Lordship, that is my instruction, Lordship, no such.
And simply because you obtain information under the RTI after passing of the judgment by the division bench, what is the case for review? How it is the case for review, sir?
Lordship, the error crept in because there was no
There
affidavit
was
filed by.
no such error. In fact, you have never demonstrated before this court that they have granted relaxation to the OBC persons.
Lordship.
Then what is the fault in the court's
Lordship,
order?
the impugned order, Lordship, the impugned office memorandum 33/2016, which formed the basis of the entire judgment.
Yes.
Lordship, that says that all other categories also includes OBCs.
Sir,
State
what-
came with
what the
state came with an
Senate-
affidavit,
just a
Lordship,
minute.
that
वो file देना जरा.
Lordship.
What the division bench has said.
Lordship, the division bench held that since the state government is saying that they have not granted
So
the
what
OBCs.
was the material before the division bench or the learned single judge to take a different view?
Lordship, because
What
the
was the
state
material? Now you are placing the material after passing of the judgment. That
Lordship,
can't be
the
the
fact-
scope of review, sir.
Lordship, the fact that Lordship, this
That
OBC
can't
were
be the
granted.
scope of review.
Lordship,
We are
that
sorry.
OBCs were still granted, Lordship. There are office memorandums of the government saying that they were granted on the basis of central government as well. Prior to that also, Lordship, that was granted. And Lordship, the core finding was that never they were given, but the fact remains that they were given, Lordship, through records.
So
we have
whatever,
received.
yes, you should have argued or stated before the division bench. What's the fault in the division bench order?
Lordship, those materials were not before us, Lordship. On that very day,
Who has to
Lordship,
provide that material?
Lordship, on the very day when I was making a
Who
submission,
has
I
to
placed,
provide that material?
Lordship,
You have to.
Lordship, we
And if you have
provided.
not provided the
Lordship, on
material,
the
then
very
what's
day,
the wrong with?
Lordship, on the motion stage itself, Lordship, it was dismissed. We didn't have the opportunity to bring that document on record.
Sir, when you ask for opportunity, you just show us. Okay, we are giving some additional facts. Where is that?
Lordship, it was only on the fact that, Lordship, the state government came up with that idea that no, we have not granted any opportunity to the OBCs to come for relaxation. And that was the categorical finding. If I take my Lordship on page number 46 of the
Not the scope of.
Lordship, page 46 for a moment, Lord. If I may take Lordship at para number 17, that is the single judge's finding, Lordship. The seat submission was vehemently contested by the learned government advocate, Mr. This. The learned advocate submitted that it is a specific stand taken in the affidavit filed by the respondent till 25/4/2018 there was no benefit of 3 years given regarding upper age relaxation to the OBC MOBCs. Now, your lordship, if your lordship takes up this
You just,
RTA,
para number 18 of the impugned judgment, come to that. Of the division bench judgment.
lordship's para 18. Lordship, is it the division bench judgment, lordship?
Yes, division bench judgment.
Lordship, it contains only 8 paragraphs, 10 paragraphs. Lordship has taken up this single judges, I suppose. Lordship. The division bench judgment starts at lordship 260.
Which page, Mr. Patel?
Lordship 260 is the page for the division bench judgment, lordship. 260 lordship. 260 lordship. The relevant portion starts from there.
Yes.
Lordship, there is a Supreme Court judgment, lordship. I'm just placing for my lordship.
Yeah.
Lordship,
Leave it. We are condoning the delay. Come on, merits
Lordship.
of the review petition. Leave it.
Lordship,
We are
lordship, I
condoning the
take up
delay.
the division bench judgment, lordship, for a moment, lordship, at para number 4, lordship. Para number 4, lordship,
Yeah,
at page number 265.
Yes.
Okay. Mr. Learned Counsel representing the appellant vehemently and fervently contended that the office memorandum dated 25/4/2018 had come into effect immediately during pendency of the ongoing recruitment process, and it is in the category of beneficial legislation. The advantage thereof should have been extended to the appellant writ petitioner and similarly situated person. He urged that the office memorandum dated 25/4/2018 clearly provides that the same was being made applicable with immediate effect, and thus mandate of age relaxation of 3 years from the existing upper age limit in respect of the candidates belonging to OBC MOBC came into force with effect from 25/4/2018, and hence the office memorandum had to be applied even to the ongoing selection process. He thus urged that the learned writ court was not justified in rejecting the prayer of the appellant for grant of age relaxation by ignoring the mandate of the aforesaid government circular. Mr. Vitara implored the court to accept the writ appeal, set aside the impugned order, and direct selection of the appellant on the post of veterinary because the appellant had succeeded in the viva voce process and after being provisionally permitted to participate. Lordship, the person was already permitted to
Read,
participate.
read.
Lordship. The second paragraph. Lordship. Per contra RB, learned advocate Mr. This and This, appearing for the respondents vehemently and fervently oppose the submission advanced by the learned counsel for the appellant. They urge that the terms and conditions of the advertisement, more particularly the condition regarding upper age limit as provided in clause 6, therefore clearly provide that the upper age limit of the candidates belonging to the general category would be 43 years as on 1/1/2018. This clause also provided that the upper age relaxation would be admissible only to the candidates of reserve category. This is important. As per the existing provisions, it was contended by the learned counsel for the respondent that as OBC candidates are not covered under any reserve category, no age relaxation could have been extended to them in the subject recruitment process. Lordship, for a moment, thus impugn office memorandum, that is at page number 351.
April 2018,
2016, Lordship.
25/4/2018.
Lordship, that was a subsequent one. But we were basing on the 2016, which says that all category that includes OBC. Lordship. Lordship, at page 98 of the Annexure P2. Lordship. If I may. Lordship, page 98, if I may, Lordship. Office memorandum dated 3 March 2016. Lordship.
Then you just read the judgment, we'll consider. We have taken note of that. You read the judgment.
Lordship, basic upon that, your Lordship, may be pleased to come at page number 322 for a moment, Lordship. This is the RTA of the department itself, in which, Lordship, they had been
Sir,
given
you
on the
just
basis-
please read the judgment first of all,
Judgment,
then only
Lordship,
we come
Lordship.
to whatever your argument.
Lordship.
We
As the,
are
please,
not re-hearing the matter, we are on the review petition. You just satisfy us, yes,
Lordship. So, Lordship, is page number 266, Lordship.
yes.
As the appellant and the other writ petitioner participated in the selection process, being aware of the opposite condition of the advertisement, without challenging them, they cannot now be permitted to turn around and claim that the condition is bad in the eyes of law. On the submission, learned counsel for the respondents implored the court to dismiss the writ appeal and affirm the impugned judgment passed by the learned signatures. We have given our thoughtful consideration of the submission advanced at the bar and have gone through the impugned judgment and other materials placed on record. It is an admitted case of the appellant herein that he had crossed the upper age limit of 43 on 1/1/18 while filing the application form in the recruitment process. Condition number 6 of the advertisement, which is at paragraph 27 of the impugned judgment, clearly provided that the candidate should not be less than 21 and more than 43 of the age, as on this and this, as laid down in the office memorandum dated 3/3/2016 and 26/9/2016. This clause further provided that age relaxation of upper age limit would be admissible for the candidates of reserve category as per the existing provisions. There cannot be two views on the aspect that OBC category candidates to which the appellant belongs do not fall under any reserve category, and thus we are not entitled to any age relaxation in the subject recruitment notification. Having participated in the selection process without any protest on the aspect of upper age limit as provided in clause 6 of the advertisement, the appellant cannot be allowed to take a U-turn and claim that he had to have been given the benefit of age relaxation beyond what is provided in the advertisement. Doing so would tantamount to changing the rules of the game after the ball is set ruling. Such an interpretation would affect other similarly situated persons who could have applied for the post in question if age relaxations provided by the office memorandum dated 25/4/18 was made applicable to the subject selection process. The office memorandum dated 25/4/2018, on which the appellants could heavily rely, was made effective from the date of publication. This clearly means that the effect of the office memorandum was prospective in nature. Any attempt to apply office memorandum dated 25/4/18 to the subject selection process, which was initiated on 17/2018, would have the effect of making it retrospective, which is not the intention of the office memorandum. Thus, there is no merit in the contention that the appellant has to be given the benefit of the office memorandum. The judgment of this and this was heavily relied. Lordship will kindly see page 322 for a moment. Lord.
Yes.
Lordship, this is the recruitment of the same department, Lordship. If I take my lords to the first, after Lordship, the block has ended. Candidates fulfilling the following eligibility conditions while submission of application shall only be considered. Lordship, age between 18 and 38 on 1/1/2013, relaxable up to 5 years to ST candidates and number 2, 3 years for OBC, Lordship. Fine. Lordship, the same department has given it relaxations to the
Why
OBC.
not raise this point before the learned single judge or before the division bench? This fact, it is not this, that you were not aware of this fact?
Lordship, these entire records, Lordship, we could only obtain after through RTL.
Then it can't be, sir. If it was not placed before then what is the case of review?
Lordship, this.
Had it been the case that you have produced before the learned single judge placed on record these facts and the division bench, and they've ignored it or recorded a finding against it, which could be treated as a perverse. How review in review jurisdiction we can't allow you to argue on merits again, sir. You know the limitations of the review jurisdiction.
Lordship, very well.
Error apparent on the face of the record. What is the error apparent on the face of the
Lordship,
record?
Lordship,
This was not before the learned single judge or before the division bench.
Lordship, this is a new fact, Lordship, which came subsequent to our hands.
So
Lordship.
that's why what I'm asking,
Lordship, discovery
subsequent,
of the subsequent event, Lordship, would cover
that
into
can't
the
be the
review.
scope of review. Sorry, sir. That can't be
Lordship,
the
in
scope of
Maharashtra,
review. Your whole case is that you came to know about some facts which are relevant after the decision. That can't be.
Lordship, the fact would remain that, Lordship, the OBCs were given relaxation by the.
Maybe your case is that whatever the decision of the learned single judge or the decision bench is against the law, that may be another thing. You can very well challenge it before the higher forum, not in the review petition, sir.
Lordship, this is in
You are
fact.
attempting to argue the matter on merits again. That certainly is not the scope of
That
the
is not permissible, Lordship. On merit again, I cannot argue until and unless the review is granted, Lordship.
merits, sir.
Lordship, this fact.
You are arguing on merits.
Lordship, my sole contention would be that, if this error is corrected, Lordship, this would
We are not
certainly lead to
disputing
the.
that you may have a case, but while exercising review jurisdiction, this court can go into this matter up to this level.
Lordship, for a moment, if I may place order 47, for a moment, Lordship, because discovery of a new fact on the ground.
Discovery of
If
the
I'm not
new
troubling my
fact.
lords on that.
Okay, what fact emerges after passing of the judgment, sir?
Lordship, this.
This fact was very much there. This fact was very much there. This fact
Lordship,
was very much there.
Lordship, we entirely argued on the basis that OBCs were always given relaxation on the basis.
So
And
you
the-
entirely argued on that basis and the decision was granted on that basis.
Lordship,
If you have not raised even argument, how we found fault with the judgment, sir? CPC.
Lordship, order 47. Release. If I may, Lordship.
Yeah.
Lordship. Application for review of judgment. Any person considering himself aggrieved, number A, by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or number C, by a decision on a reference from a court of small causes, and who, Lordship, this is important, from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge, or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of record, or for any other sufficient reason, desire to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the
Yes.
court.
Now, what is the due diligence?
Lordship, at that point of time, Lordship, we didn't have the access to this document because it was
Why?
really within the domain of.
So what, now some new law came or what happened? So that was at that time, despite this exercising due diligence, you have not been able to that. Where is that? Have you attempted that? They have not given you any information or what happened?
It was a discovery of a new and important fact, Lordship, which came
May-
subsequent.
Certainly, new and important fact, but there is the question of despite due diligence,
Lordship, that was not, Lordship, after
was
the,
not done.
Lordship, at that point
That's why
of time, Lordship, it was not within.
scope of review is very limited.
I certainly leave it to my lord because, Lordship, this is a fact, Lordship, which goes to the root of the entire matter, Lordship. And
Absolutely.
very correctly, Lordship, if I may.
Absolutely, but why you have not placed before the court? Who prevented you? Despite exercise of due diligence, you have been failed to show us. We'll exercise the review jurisdiction.
What is, that is what Lordship would do.
That is not-
RTA only we could gain that document that since they have not exercised this OBC, the relaxation was not given to them. That is the only point of.
So now you became wise enough after passing of the judgment by the learned single judge as well as the division bench. Then, sorry, sir, can't help you.
That is what Lordship I could already say. Otherwise, Lordship, this issue could have been
It's almost 1.5 years. The learned single judge has passed the judgment, 1.5 years, and more than 1 year after the division bench judgment.
And Lordship, the fact remains that Lordship, they have not filled up the post because subsequent recruitment process has not been initiated.
Forget about it, sir.
Lordship.
Forget about it. But what about this?
Lordship, in my respectful submission, Lordship, since it is on the meritorious case, Lordship, that
Meritorious
review
case,
could have
you may
been,
very
could have
good
been
case on
allowed,
merit,
Lordship.
but sorry, sir. Exercising review jurisdiction is not prescribed.
Lordship, certainly rehearing is not permissible under a review, Lordship.
Then,
Lordship,
what-
but Lordship, as
know the
regards the
limitations of
error,
the court, and despite that, if you are asking, then
Lordship, the
Sorry.
error as it remains, Lordship, that the OBC has already been granted the relaxations. And Lordship, we could place this fact only because we filed an RTA subsequent to that.
Yeah.
That is what, Lordship.
the matter comes upon for consideration of the IN number 1524/2024. With a prayer to condone the delay of 174 days.
Lordship, 212, Lordship. in my-
Officers calculated it as 174 days.
Maybe, Lordship.
$174 in filing the connected
But if I may add one more thing, Lordship,
medieval which filing the connected review petition. Stop. It is stated in the review petition that the facts which has been specifically mentioned in the review petition came to know to the applicant after passing of the order passed by the division bench in writ appeal number 358/2023, which was dismissed on 19/10/2023. It is stated that the state has non-suited the applicant on the ground that no relaxation in age is provided to the OBC candidates. However, later on, the applicant discovered that during that period, the state has granted, during the relevant period, the state has granted relaxation benefit to the OBC candidates in various recruitments, including the recruitments in the veterinary department. Learned Counsel has submitted that since the information which is relevant and important is received by the applicant after by the applicant through RTI, the delay in filing the review petition may kindly be condoned. Stop. While taking into consideration the application preferred on behalf of the applicant under Section 5 of the Limitation Act, the prayer to condone the delay in filing the review petition, we have gone through the, we have also examined the matter on merits. Stop. The applicant, the applicant has applied for recruitment pursuant to the advertisement issued by the Assam Public Service Commission. Advertisement 1/2018 dated 17th of February 2018, issued by the Assam Public Service Commission, hereinafter to be referred as APSC, from eligible candidates for 113 class second gazetted in bracket junior post of veterinary office and block development veterinary officer under the animal husbandry and veterinary department, as well as for various other posts under the different department of government of Assam. The application of the applicant was rejected by the APSC on the ground that he has crossed the overage, crossed the maximum age limit on the last date of submission of the application of the last date of submission of the application pursuant to the aforesaid advertisement. Full stop. The applicant has challenged the said action of the APSC by way of filing a writ petition, wherein the state has taken a stand that the members of the OBC category, candidates of the OBC category have not been treated as a candidates of reserved category, and therefore the age relaxation of 3 years provided for the reserved category has not been extended to the applicant and other similarly situated persons. Stop. The learned single judge, after taking into consideration the stand of the respondent state as well as the APSC, has dismissed the writ petition while impugned judgment dated dated 1/6/2023. Being agreed with the same, the applicant has preferred, the applicant has preferred a writ appeal number 358/2023, which has also been dismissed by the division bench of this court. While observing that since the OBC category candidates to which the applicant belongs do not fall under the reserved category, and therefore they are not entitled to any age relaxation in the recruitment in question. Full stop. The division bench has also observed that having participated in the selection process without any protest on the aspect of upper age limit as provided in clause 6 of the advertisement in question, the appellant cannot be allowed to take a U-turn and claim that he ought to, the applicant cannot be allowed to take a U-turn and claim that he ought to be given the benefit of age relaxation beyond what is provided in the advertisement. Stop. Learned counsel for the applicant has submitted that after the dismissal of the writ appeal, the applicant has moved an application under the RTI to ascertain whether during the relevant period, the benefit of age relaxation was granted to the OBC candidates or not. It is submitted that the, as per the information supplied to the applicant under the RTI, it is clear that the state government APSC has not granted relaxation, or APSC has also granted relaxation. Not
These are
APSC.
departments, Lordship, there are 13,
That
around 13, 12.
that the benefit of age relaxation to the OBC candidates have been extended in various recruitments, including in
By the
one of
state of-
recruitment in the veterinary and veterinary department also.
Also, Lordship.
Stop. The learned counsel has submitted that since it is a discovery of an important and new and important fact this court should take into consideration the above facts and may allow the review petition preferred on behalf of the applicant. It is contended that the appellant, that the applicant is being subjected to discrimination because the similarly situated persons have already been granted the benefit of age relaxation, whereas the APSC has denied the said benefit to the applicant illegal. Stop. It is to be noticed that the fact, having heard the learned counsel for the applicant, we are of the view that from the review petition as well as the application for confirmation of delay, the applicant has failed to make out a case that the discovery of the new and important fact or evidence was not within his knowledge, despite exercising due diligence in the despite exercising due diligence. The facts which the applicant now attempted to bring on record were very much in existence, and it is not the case of the applicant that he was prevented from collecting those facts during the pendency of the writ petition or the appeal before this court. Full stop. Since the applicant has failed to satisfy us that the new and important matters a new and important fact was not placed before the court despite exercising due diligence. We are unable to grant the relief, we are unable to grant the review of the impugned order passed by the division bench in writ appeal number 358/2023. As a matter of fact, by placing certain new, as a matter of fact, by filing this review petition, the applicant has attempted to argue the matter on merits again, which is certainly not the scope of the review jurisdiction. In view of the above discussions, this application for confirmation of delay as well as the review application number so and so is dismissed.
All right.
For addition, item 5.
We have filed our affidavit.
Affidavit, you have already filed. Who is appealing for the petition? Pass over for the timing.
Public.
Item 8.
In item 8. Lordships, 7 more districts are yet to file their affidavit.
Yes, Lordship. One is ready and other 6 yet to prepare, Lordship. Everybody is ready, Lordship. We are going to file within the week, Lordship.
When you are going to file?
Within the week, Lordship. 8.
There were is the remaining districts were there.
Lordship, above, remaining 6 districts after vacation, Lordship, we shall file.
No, so you have submitted the detail regarding how many districts out of those 7 districts?
Lordship, 7 going to file this week, Lordship, and other 6, Lordship, after vacation, Lordship.
24. Okay.
Okay, then,
24
one
have
second.
been.
Waiting for the. Wait, there's some more time. Submit the required details in respect of the remaining districts. List of you will.
Deeply.
Item 6.
May I please, Your Lordship? Lordship, in connection with the item number 6, WPC number 6253, I have already filed one IA. Can you
You
take
have the
a
copy of that IA?
IA?
Give us the copy.
Lordship, up to respondent number 12, it's okay.
Why this application? What application?
Lordship,
You want what?
kindly come to page number 12 of my WPC.
Page number 12 of
12 of my WPC,
repetition.
read petition. Here, Lordship got it?
Yeah,
Lordship, up to 12 respondent number, it's okay. Then it should be the divisional personal officer 3, Rangian, NFLA, post office Rangian, so and so. he was made party as respondent of necessary party as because he has issued very vital document, which I have already annexed with the IA. And he was made party in way also before the honorable tribunal bench. But
Which
due
one?
to divisional personnel officer, he should be implemented respondent number 13, then respondent number 14, the chief vigilance officer T Maliga, he should be 14, and then respondent number 14, the chief inquiry inspector headquarters, he should be made as 15. This is once divisional personnel officer will be implemented as 13, subsequently 14 and 15 will be replaced by, will be numbered as 14
If
and
we
15.
implement the divisional commissioner as this respondent number 16, whether 15, what's the problem? It should be implemented as 13 and then only these were why? And where is the question of now? Come to the merits of the case. What is your merits?
Merit is
You have obtained appointment on the basis of some fraudulent documents, false documents, that's all.
Lordship.
This is what charge against you.
Lordship, that is
You sought compassionate appointment or you obtained the compassionate appointment on the basis of some false documents,
Lordship, that is the allegation.
fake documents.
Charges has been leveled against me.
And that has been proved.
Lordship, that has not been proved. Lordship, first
Then
3 articles.
without proving that,
Lordship,
you have
partially
been
correct.
punished.
Lordship, partially correct. 3 charges has been leveled against me by the charge sheet. Now, first article 1 has not been proved. Article 2 and 3 has been proved during the quasi-judicial process. Now, Lordship, what happens? The documents upon which the respondent relied upon, those issuing authorities were not examined. And as such, I have been deprived of cross-examination during the quasi-judicial process. Number 1. Number
There is a question
number-
of examining
number
that those authorities has confirmed that we have not issued any such certificate.
No, that is, I have been deprived of cross-examination to extract out the fact of the
You
case.
should have asked us to produce as a witness.
No, that is their list of documents has not been shown. Lordship, second issue is that lot of procedural lapses as well as statutory rule has been violated by the respondent during quasi-judicial process. And Lordship, very vital thing is that copy of the inquiry, copy of the complainant in question, when I sought for during the inquiry officer also referred to the competent authority. They said that it was very old case in the year of 2006. So my case docket related to me is not available, untraceable. So the thing is that during the quasi-judicial process as well as before the honorable court, copy of the complaint was not produced or exhibited. Even it was not furnished to me in spite of my seeking that one. So
Yeah, is it registered? Note, the matter comes upon for consideration of the application number so and so, in which the petitioner has paid for impeding divisional personnel officer Bangya, North Front Railway, PON pass number is this. Take note of something. As part of respondent in the petition. And counsel has submitted that the said authority was implemented as was party before the tribunal, but in this writ petition due to inadvertence, the petitioner has failed to implead it as party respondent in this writ petition. Having gone through the contents of the application and after noticing that the above referred authority was party respondent before the tribunal, we deem it appropriate to allow this application. The divisional commissioner so and so is implemented as party respondent number 15 in this writ petition. Amended cost title will be filed within a period of
Lordship,
when you are going to file amended cause title.
Lordship, after winter vacation, Lordship. As because,
Amended cause title. You should have filed along with this application.
Lordship, as because
Okay.
after
Amended
winter
cause title file will be filed by the petitioner within a period of 2 weeks. In the meantime, madam, you are appearing on behalf of
On behalf of all the
all the
respondents.
respondents. Miss And Ms. So is appearing on behalf of all the respondents. Having heard the learned concept of the parties and undergoing through the material. We are of the view that matter requires consideration, hence admit no need to issue formal notice. Place in due course. As
Highly
parties
obliged,
are
Lordship, highly obliged.
due. Amended cost title, you should file.
Lordship.
Item 9 to 15.
These all issues are arising out of common judgment, Lordship. Under section 130 of the Section 8. So the appeal is to be admitted on substantial question of law.
Which appeal?
This 9 to 15 laws.
Already admitted,
No, not admitted.
not admitted.
There was a delay was condoned. My landed is appearing for all the respondents.
question of law in this.
Lordship, in this case, Lordship may come to page 77
Taking
of
into
the.
consideration the evidence, and he said, okay, since the, this, whatever the recovered gold is not seems to be, is not,
Pure.
this, what eligibility mark or something. And there is, they were carrying voucher with them.
No, Lordship, this is not correct. They've admitted in their, before the junior
Simply
operating.
because this 108, they have retracted their
Lordship,
statement, and as per the Punjab and
that
High Court, they have said they.
Statement recorded before during investigation, if subsequently retracted, that can be relied. That is held by the Honorable Supreme Court in.
That can be relied certainly, but the court has to take into consideration
Lordship.
whether that was this confessional statement were voluntarily or given under duress or
Lordship,
whatever it may be. That can't be in each and every case. It can't be a.
No, Lordship, may please to
Something-
see the finding of that land tribunal.
Yeah, the,
Page 77,
yes,
paragraph 9.
paragraph 6 only, nothing else.
On careful consideration, paragraph 6. Record the place before us, that the only issue before us is that whether 3327 gram of gold can be absolutely confiscated without having any item of evidence that the gold being smuggled in nature. In fact, the case of the town seizure and the appellant were carrying job or voucher with them in support of the claim. Moreover, the test report also certified that the quality, purity of the gold is not up to the mark. Lordship, under section 123 of the Custom Act, but may please to see the section 123.
Ultimately, what is the question of law?
The question of
These
law.
are the question of fact.
No, question of law is that whether under section 123 of the Custom Act, purity can be a question, can be decided by the land triangle. Lordship, may please to see 123. There is nothing has been
Give us
stated
the-
in
get
section
the-
123.
My lord, otherwise also it is inadmissible since it is below the monetary limit prescribed by the government of India.
Below the,
Monetary limit prescribed for filing appeal by the
that is 2 crore.
No, Lordship. in
1
case of-
crore before, my lords.
It is, value is the 1 crore 57 lakhs. And the latest notification is not applicable in case of custom. That is applicable in case of central excise and service tax only. The latest notification, 2 crore Lordship.
2 crore is
I have-
applicable to Customs Act. It is issued under the Customs, section 131
Lordship, I have,
PA of Customs.
we have already checked up this issue. That is not applicable, notification dated 6 of August 2024 is not applicable in case of custom law.
You have checked from where?
Not department law.
The custom department and the custom department itself has issued.
No, it is 1 crore. Lordship, 1 crore is the value. Here the value is 1 crore 57 lakhs.
No, this, I got 1 crore.
My lord.
Yes, it is 1 crore. Here value is.
Exercise of powers, first of all, you clarify it whether it is applicable or not, then
No,
only we'll go with this.
1 crore is applicable. Here value is 1 crore 57 lakhs.
My lords.
Here it is 1 crore 57 lakhs.
Other day, you mentioned some notifications where the, this
That
was
is-
announced. Up.
No, it is applicable in case of central excise and service tax only. That is 2 crore. We drawn many cases.
My lord, custom and central excise, these are 5 crore, central excise and service tax. In respect of customs, it is 1 crore and 2 crore. My lord, this notification was issued in
1 crore and 2 crore means
1 crore before my lords and 2 crore before
the
Honorable Supreme Court.
fine.
And my lord, on on this very aspect that the appeals are below the limit, Honorable Supreme Court disposed of 573 matters by a single order, which I have placed before
That's
my
right.
lord.
Sir, these, this, whatever the cost or which they have mentioned of this 3327.40,
My lord,
that cost goes to
that goes to 89 lakhs, my lord.
89 lakhs.
89 lakhs. My lord,
Where we got this?
my lord, I'll explain, my lord. Initially, there was a seizure of 5 kilograms, and later it was one claimant did not come forward for filing appeal before the Honorable CSTAT, and therefore 2 kilogram seizure became absolute. 3 kilogram out of 157 comes to 89 lakhs, which is before my lord today. My lord, we have calculated this is the seizure which is from individuals which is less than 31 lakhs each. Penalty added to that comes 34 lakhs, 34 lakhs, and 36 lakhs. My lord, and there is a judgment of Allahabad High Court, which I have placed before my lord, which is on page 30 of my compilation, my lord. My lord, starts from 31. Neutral citation number 2024, Allahabad High Court, 48658 DB. My lord, the relevant part is on page 34.
Yes.
My lord, the circular has been extracted here, and after extracting the circular, thus it is litigation policy of the Union of India not to prefer or press revenue appeals wherein revenue implication may not exceed monetary limit of 1 crore. While the confiscated gold was valued more than 1 crore, at the same time, that was apportioned amongst 3 assessees, namely the so-and-so, so-and-so, and so-and-so. Thus, individual dispute in each of the appeal is far below the monetary limit of 1 crore. On the earlier date, we allowed learned counsel for the revenue to file supplementary affidavit to bring on record the revenue effect involved in each appeal. While an affidavit has been filed by the revenue on 18/11/2023, it does not bring on record the revenue effect involved in each case of the appeal. In fact, paragraph 6 of the affidavit, it is been stated as below. That in view of the direction given by the court, white order dated so-and-so and dated so-and-so, the present affidavit is being filed to bring on record the fact that objection regarding monetary
Maintainability,
my lord,
maintainability of the appeal raised by
maintainability of the appeal raised by the respondent on the ground of duty component being less than the amount prescribed by the board for filing appeal before the Honorable High Court has to be turned down in view of the fact that the question of quantification of duty does not arise in present case, as no duty whatsoever was demanded confirmed in the present case. Clearly, despite time granted, no disclosure has been made by the revenue to establish that revenue implication in each of or any of the appeal exceed the monetary limit of 1 crore. Since the order passed by the tribunal is clearly in favor of the assessee, there is no cross appeal filed by the revenue, no justification or occasion survives for this court to allow the revenue the luxury of maintaining the present litigation against its own stated litigation policy.
So here the value is 1 crore 57 lakhs.
total.
Total loss.
How many persons?
Lordship 7.
So if it is bifurcated amongst them, then
No, Lordship, may please to see.
why,
because-
that's why only you have filed the separate appeals.
No, because as per law, Lordship, we have to prefer the separate appeals, but
So in each case, what is the total revenue
it was
involved?
collectively it was seized. Lordship.
Collectively, sir, that,
Lordship, may please to see. This is
then
not,
what about this judgment, sir?
which one?
This Allahabad judgment.
Lordship, here, the question is the value of the appeal. Value of the appeal is 1 crore 57 lakhs. I can prove, Lordship. And Lordship, in case of, there is a notification of the department, 26 of 2024, which says,
Your own policy.
Yes, Lordship.
And you are against that same policy. This calculation, you have supplied them this calculation.
My lord, we have here. This
Is it wrong, sir?
इसके against कोई figure नहीं है, figure part के against that.
no, Lordship,
Figure is not against.
Lordship, may please to see the execution order, Lordship. Let me verify everything.
Oh, which order?
Executing authority against which the petition respondent has preferred appeal before the 6th of April. If you page 69, paragraph 33. Merit law. Paragraph 33. Sri Anil Kumar Jain.
Just a minute. Season memo,
That's it.
season memo,
That's it.
season memo.
Season memo is we have not. Let's tell what is the ordinary
Sir,
record.
here can we see is acting on intelligence so and so, as the DA officer identify themselves so and so, so and so, the DA search the 5% recovered. You have searched 5%.
Yes, sir.
And from them you recovered some amount of gold,
Yes, sir.
which was wrapped on their waist.
Yes, sir.
So total was 5837 grams.
Yes.
What was the individual, weight they were carrying, the individual gold? What amount of individual gold they were carrying?
Look, it was collectively, it was.
What do you mean by collectively once? Then why you have filed this appeal against all the
No,
persons?
Look, because Lordship, because separate appeal is to be filed under the High Court rules. Lordship. That's why we filed the separate appeals.
Sir, even though, sir, this.
Lordship, may please to
we
see
fail to understand, sir.
paragraph 60, page 69, paragraph 33, Lord. 33, 34, and 35. Of the. They were, during the investigation, Lordship, they admitted. And the one form which they cited before the authority, that was found to be fake.
So why this penalty there was imposed separately upon them?
No, Lordship, may please to come to page 70, paragraph 36,
71,
70,
70,
70. Order passed
70.
by the executing authority.
Inventory of the
70.
Paragraph 36. Lordship. Merit law.
Yeah, read.
Paragraph 30. I order absolute confiscation of the 35 pieces of gold bar foreign origin weighing 5837 grams and collectively valued at rupees 1 crore 57
Collectively.
lakhs. Yes, Lordship.
Collectively valued.
And seized by memo number dated so and so.
And then why this penalty was imposed separately upon them?
Because Lordship, individually their role was ascertained by the executing authority, then separate
Individually?
their role in bringing the gold to India.
Certainly, sir, a person collectively you can't impose the punishment when he was having a certain amount of gold. Every person is having different kind of the different
But
amount of gold with them.
Lordship, there is one
And
seizure
that
memo.
value is less than 1 crore.
Lordship. Lordship. The value of the goods is 1 crore 57 lakh collectively, Lord.
Sir, what this order says, sir. In exchange of powers conferred with the following, fixes the following monetary limits below which appeal shall not be filed in the CC High Court or Supreme Court.
Yes, Lordship. That is.
So appeal, you just show us that the revenue implication in each of this appeal is more than 1 crore.
Lordship, in my whole submission, collectively.
Collectively, though, sir, it's very difficult for us.
And Lordship,
Digest this thing.
Lordship, may please to see the order passed by the CC.
So she said, we have seen that order, वही पढ़ रहे थे अभी, वही तो पढ़ रहे थे हम. CSET order, where is that CSET order? Yes,
This is a single order.
yeah, they've simply said that this can't be done.
It's, the finding of the landed tribunal is that first, the POT board is not up to the mark. And secondly, it was seized in the town. And secondly, statement recorded at one
Sir,
zero eight.
confiscated without having any iota of evidence that the gold being smuggled in nature. In fact, it is a case of town seizure of a job work voucher with them in support of their claim. Moreover, the test report also, 3 grounds they have taken.
Lordship, that is why we have submitted one substitute motion law that the finding of the landed tribunal is perverse.
Sir,
To the
first of all,
executive
you
authority.
please satisfy us that this is not covered under this notification, then we'll come to the merits.
No, Lordship, because the value of the appeal is 1 crore 57 lakhs collectively. And Lordship for 2026.
We file an affidavit of this effect that
Lordship.
in each and every case, the revenue implication is more than 1 crore.
No, Lordship, individually it is
You
below.
file
1 crore.
an affidavit.
Yes, Lordship, I'll file a
In each appeal, the revenue implication is more than 1 crore, then only you can maintain the appeal.
Yes,
Otherwise,
Lordship,
no.
that is there.
You
Lordship.
can't do that.
Yes, Lordship. I can file a affidavit.
Okay, you can file
Yes.
an affidavit. Fine.
My lord, I have the seizure memo. It says 7 bars each were recovered from the 5 intercepted persons.
No description.
My lord, it is there. Names have been given. Their names have been
What
given.
amount of gold they were carrying, each of them?
7 bars each.
7 bars each. Okay.
That will amount to 1137 grams each.
Lordship, there is an authority here. If he is collectively seized, then it will be counted as one Lordship. That judgment is
Yeah,
there.
show us the authority.
I'll
and
place
we'll
that.
consider.
I'll place that.
Okay.
Yes, Lord.
These present custom references are preferred on behalf of the revenue being agreed with the order dated. What is the date of order?
Lordship, order date
12
is
7
23.
12 7 2023 in as many as 6 custom appeals referred on behalf of the
7 ballots.
7
7
7 custom appeals referred on behalf of the
Custom Department.
respondents hearing each appeal. Full stop. Learned counsel for the respondents has raised the preliminary objection that the appeals that each of the appeal in each of the appeal, the revenue implication doesn't exceed the monetary limit of 1 crore. And therefore, in view of the notification issued by the Ministry of Finance Customs Department dated 2nd of November 2023, the revenue cannot maintain the present appeals as the same would be against the litigation policy of the department itself. Learned counsel for the revenue, Mr. Kyle, has submitted that since the cost of the gold recovered from each of the respondents is more than the cost of the collective gold. The collective cost of the gold recovered from each of the appellants is more than 1.50 crores. The appeals referred on behalf of the revenue are not supposed to be disposed of in terms of the litigation policy of the customs department. Stop. In view of the rival contentions, we direct the council for the revenue to disclose that the revenue implication in each of the appeal exceeds the monetary limit of rupees 1 crore. Mr. Kayal may file an additional affidavit clarifying the extent of the revenue while supplying the copy of the said additional affidavit in advance to the council for the respondents. List this matter in the month of February. In the meantime, the council for the if desires so.
There is a subsequent notification dated 26 June
Sir, you
2024.
please place on record everything.
No, Lordship. No, Lordship, with regard, my management submitted one notification of 23. There is a subsequent notification, the same monetary limit has been fixed, but some condition has been let down.
Place it on record, we'll
Lord.
consider on that.
My lord, may it be date fixed because I have to come from Delhi,
10 February.
10 February. Oblige, my lord.
Item 16.
Please, Lordship. Lordship, in this case, I have to file affidavit, my lord. Affidavit is ready only in last week, my
There are
lord.
some operational.
Yes, yes.
Yes. So
I have served a copy to my learned friend also, my lord.
I'm not, like, officially I haven't received it.
what do you mean by officially, whether he has served it?
No.
Yes. I have served one copy to him, my lord, but it could not be filed, my lord, because of my non-availability of the deponent, my lord. It will be filed during this week, my lord.
My lord, another small prayer I need to make, with regard to respondent number 2, under, section 25 of the act, they were required to file a mandatory report in front of the state legislature with regarding the compliance to section 4 and other mandatory requirements under the RTI Act. If they have done the same, that will be brought on record.
Like that is available on record, we'll bring it on record.
Whatever the.
Yes, but.
Now.
Time for restaurant number 5, my lord. We have already completely been record.
You already?
Compliant, my lord.
Okay, fine, so we'll hear you.
My lord.
Look here, Mr. Sharma and Mr. So and so, please some more time to place on record the steps taken by the respondents for addressing the issue raised by the petitioner in operation of the online portal as required but under the provisions of the RTI Act. It's fine. Listing February.
Obliged.
Item 17.
Please, my lord.
Supposed to file an.
We filed that, Lords.
When?
Lords, we filed it.
Also, we have not received.
On
any
26th of November.
26th of November.
Yes, Lords, we've already filed that.
Yeah.
In terms of your Lordship's last order, my Lord.
And affidavit 27. It starts from page.
Start from page 68. 68, my Lord. Running page 68, yeah.
68.
Has he not served on us, Lordship?
Not, sir.
Not,
No
yes.
copy has been served.
The departments were served, Manoj, that's what
I'm
my
appealing,
friend tells me, Manoj. Everybody has been served.
Forest was served.
I'm appealing for respondent number 1 and 2, Lordship, central government.
I'm appealing for the state of Arunachal Pradesh.
You're also.
Well, the lordship may in the meantime, if a lordship may consider issuing notice, Manoj, we can serve them copies in the
Sir,
meantime.
once they are appearing, where is the question of issuance of notice?
Very well, Manoj.
When they are
Very-
already appearing,
very
they
well.
file their response.
Very well.
So simply on account of that formal notice, when the parties are here, really.
No difficulty, Manoj, if lordship is falling, no.
Click here. It is stated by the concept of the petitioner that pursuant to the direction given by this court on pursuant to the liberty granted by this court on 18/11/2024. The additional affidavit has already been filed on behalf of the petitioner. However, the counsel appearing for the respective respondents have submitted that they are not in receipt of the said additional affidavit. Be that as it may, the counsel of the petitioner is directed to supply the copy of the additional affidavit filed before this court on 27th of November 2024 to the counsel for the respondents during the course of the day.
Yes, Manoj.
During the course of the day, the counsel for the respondents may file their response if required so to the said additional affidavit by the next date of hearing, put up in February.
Manoj, may I ask for 28th of February if it's okay?
As the by the counsel for the yes. Put upon 20 listed on 28th of February as paid by the counsel for the.
Manoj, and if lordship, Manoj, if they want to file any reply to the PIL, they can do that, Manoj, in the meantime.
Whatever it may be, if they want to file PIL or the additional affidavit.
Because I'm only saying so that Manoj, another date is not wasted. If they want to file, they can file it in the meantime.
In the meantime, the respondents may file response to the additional affidavit as well as the PIL if desires.
As my lord. I'm so grateful.
Item 18,
Yes, Mr. Das, you are for?
I am for the respondent number 7, 8 for the company, Airtel company.
It will come.
I'm for the respondent number 1, the person your lordship. But whose amount your lordship,
Who?
State Bank of India,
they have come, State Bank of India filed the appeal.
Who is appealing for State Bank of India? And what
A.
happened,
Das was,
what happened before the learned single judge?
the single does, your lordship, the matter is proceeding finally because since the amount which was directed to be paid as an interim, because it was the pensionary benefit which was.
That's right, but
Yes.
But the
That,
learned-
since your lordship has stated that rest the proceedings are there, the in the government of India have filed the affidavit there. They found that the Airtel, there are some defects in the swapping of the SIM by the Airtel.
whatever it may be, ultimately the learned single
Well, learned
has given a
single-
finding,
Yes.
a prima facie finding that the SBI was not at fault.
Yes,
And it appears that they find some fault with your,
yes.
whatever the.
But that has been taken care of by has served a so-called notice to us. And we have given a reply. There's a different aspect of the matter. But your lordship is asking what has happened to the learned single judge. Learned single judge is very frankly is finding difficult because there is an interim order which has been passed. The matter comes up,
So we'll make it clear
yes.
that the only up to this part and the learned single judge may proceed further with the final hearing of the matter. Staying this part of making payment.
Because there is no indication by your lordship also. A learned single just cannot go beyond this
No,
because
certainly we
that
have not
part of the order
maybe we have
is finding.
we have failed to clarify in this order,
Yes.
but now we'll clarify. Ask the concept of this SPI will dispose it of. Now.
State by complete, yeah. Now we have.
Who is the paying? Mr. K. Das.
Here.
Okay, pass it over for the day. You please try to contact him. Ask him.
If I have it day after tomorrow, in the meantime, I'll ask.
We are going to dispose it of today itself.
Okay, yes.
You, if he is not available, then we'll consider it.
I thought your lordship is passing over, that's why.
Passing over for the time being, you please make a call to him and ask him if he is appearing or not.
Item 21.
But Lordship, on last occasion, Lordship has granted me time to file an affidavit in the matter.
Challenge this order. Why?
My lord?
You have challenged this order.
Yes, my lord.
Why?
My lord, basically,
In your favor.
no, my lord.
Whatever the deductions.
Yes, but
The court has set aside that and only set have a no inquiry or whatever.
but the law is that, my lord, the disciplinary proceeding was initiated before my retirement and it was concluded even before my retirement. So what have done by the learned single judge, that the learned single judge has converted the whole proceeding, set aside the penalty order, and the whole proceeding was converted to a rule 21A. My lord, that cannot be done. That is my humble submission. Because rule 21A of Assam pension rule, it reserves to the governor only. The power exercise can be by the governor only, not by the board. My lord. And in that case, there must be some pecuniary loss also caused by the government. counter file করে send you the কৰিব। My lord.
What's wrong with this order?
My lord, the wrong is that disciplinary proceeding was initiated with the so called notice on 4/7/2015, my lord. Thereafter, on 3rd of March 2017, penalty order was issued, my lord. So in that case,
That Learned Single judges have taken care of that. That in the rule 7, you can't impose a penalty of withholding of pension
yes,
till the.
because
government
in the
submit was-
list,
till the government service order, servant was under service.
Yes,
It can only be imposed after retirement.
yes,
This is
that,
what-
that penalty order can be imposed after retirement. But here, the disciplinary proceeding was already over. There was nothing, my lord.
But the learned single judge is dismissed only on account of these technical reason,
Yes,
their punishment. Then certainly the learned single judge has rightly said as per 21A, it would be deemed that the proceedings will continue.
no, my lord.
Yes.
Because
What's
the,
wrong with
the
that?
governor only reserves the right, my lord. And when it's reserved,
21A,
yes, my lord.
21A, read.
The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether pecuniary or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government. There must be some pecuniary loss, my lord. In that case,
Read.
if in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, the including service rendered upon re-employment after retirement, provided that such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to be a proceeding under this rule, and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. My lord, the first line starts with the governor of Assam reserves to himself the right. That cannot be exercised by the court,
Sir,
my
it
lord.
is reserved the right of imposing penalty.
Yes, my lord.
Yeah. So if the governor would not.
And there must be some pecuniary loss also, my lord.
That is to be
Because-
proved by them in the departmental proceedings.
Regarding charge
You can very well argue,
My lord,
but
now,
I don't think so. This
What-
is-
my lord,
yeah,
what
we-
remains- what remains? My lord.
Suppose if you would have been remained in service and the disciplinary proceedings against you would not have been
My lord.
concluded, then
My lord,
then what happened? What would happen? क्या होता है उस वक्त तक?
that will continue, my lord.
Continue under what?
Automatically under 21, my lord.
So now if the punishment order was set aside by the learned single judge purely on technical ground, then certainly it would be deemed that these proceedings will continue under this as per rule 21A.
My lord, in that,
Can't have both the things in your hand, sir.
my lord,
You can't have both the things in your hand. That these technical ground where it is okay, you should set aside and now exonerate me. This can't be this. The learned single judge has
Already-
rightly said.
already, my lord, penalty was imposed.
Sir,
Now
that
what remains for them, my lord? Now what remains for them?
penalty- That's why only the learned single judges said, "Okay, I am interfering only on technical ground." And that would mean that
My
the
lord-
proceedings would
My
continue.
lord, that I understand. From which stage they will start? That is the query, my lord. Because
Okay.
already everything has been over. Now the remains only the penalty part, my
Okay,
lord.
we'll make it clear that this, after considering this only penalty part, from penalty part, they will again start. We'll make it clear.
My lord, can I take a chance, my lord? Maybe on another day, my lord.
Why another day, sir? You are the matter quite
My lord,
wrong.
my lord,
Why another day?
my lord, because
Get the matter
there-
settled by them.
there are some judgments of this honorable court, my lord.
Yeah.
I need to refer, so in that case,
Yeah.
my lord,
Yeah.
maybe on another date, my lord. Immediately after vacation, my lord may fix it. Immediately after vacation, I'll satisfy your lordship.
If the satisfaction once it is clear, then sir, you can't go scot-free on this technical ground, sir. We will not able to release you scot-free on.
My lord, I
technical grounds.
understand.
There are some charges.
but Rule
that should come to the
21A
Conclusion.
But Rule 21A cannot be exercised by the court, my lord. That
Sir,
is my humble submission.
Visualize this situation. If that order would not have been passed, then what would happen?
If it's continuing till his retirement, then it will automatically deemed to be continued, my lord, after his retirement.
Sir, on technical grounds, since this punishment was imposed were not as per Rule 7,
But that,
it would be deemed that under 21A,
my lord, they have already imposed the penalty, my lord.
now that has been set aside.
That is the wrong, my lord.
So you mean to say that penalty should not have been set aside?
My lord, penalty should be set aside. But cannot be converted under Rule 21A, my lord.
Absolutely, that's right.
Because the
You don't
penalty
find
was
any-
wrong, because it was not under listed with
You
penalties.
don't find any illegality in the impugned law.
My lord,
It's logical.
my lord may fix it after vacation. I will satisfy your lordships in that regard.
Vacation, how you will satisfy some new facts would come or what?
No, my lord.
Okay. Having heard the learned counsel for the parties, we are of the view that the learned single judge has rightly to the conclusion that the proceedings against the appellant would be continued under Rule 21 of the rules of 1969 because the learned single judges interfered with the punishment order only on technical ground. Learned counsel for the appellant, after arguing the matter for quite some time, raise some more time to address the court. In the interest of justice, time granted when
Any date, my lord, after vacation.
any date you have to argue, therefore choose your date.
My lord, on 6th, my lord.
6th of January,
Yes.
opening day,
Maybe 8th, my lord. Then 8th.
wicket would be very difficult on opening day.
8th, my lord.
बहुत दिन बाद आएगा.
8.
8.
Much obliged.
But only one submission I have, Lord. Only one submission I have, Lord. Pursuant to the honorable single judge order, the notification has been issued, my lord. I have given a copy on 4/5/2024, converting the proceeding. That order has been passed, and my learned friend has submitted that honorable court has exercised the power under 21A. That is not the correct position, my lord. Now the notification is there. That may be, I have already given the copy.
What notification?
That this proceeding will now continue under 21A. The second page, kindly see, my lord. On 4/5/2024.
Pursuant to the order passed by this court?
Yes, but the learned single judge has given us an option that you pass a speaking order, whether you want to continue it or not. If you continue, it will continue up under 21A. That has been already passed.
You place it on record.
Lord,
And in that regard, my lord, the learned single judge also directed to pay the whole pension, my lord.
They said they can't withhold the pension till the validity of the discipline proceedings.
They have already initiated the proceeding even. If they are submitting it, my lord.
yes,
Actually, these proceedings are culminated,
My lord.
finally culminated. Till then, you can very well.
Much obliged.
Item 23.
Mr. Majumdar, on the last occasion, he said, we are going to address the grievances. Where is Mr. Majumdar? Some deliberation is going on.
Yes, he has told me in the morning, my lord, he will come, he'll send someone to take time because he's on lag in some other court.
So some deliberations are going on or what?
He told me that's under process because they are going to give the to the science graduate teachers. Those who are science graduate teachers of the upper primary schools and their services have been amalgamated with the high schools. They would be considered for promotion to the post of headmaster of the high schools. That they are going to consider, they have told me in the morning. And regarding arts graduate teachers, they are going to, my lord, the rule, my lord, for to include the teachers of arts graduate teachers. That my learned friend has told me in the morning.
Those persons who are not who are not even graduate.
Yes, yes, for them, they are going to like.
Come, Mr. Nath. Likhiye, Mr. Nath, appearing for Mr. R. Majumdar. Learning concept for education, secondary department has submitted that the matter is active, the grievance raised by the matter is under active consideration of the state government with the view to redress the grievances of the petitioners. He plays some more time. Stuff in February.
After BU vacation, my lord. Let it come after BU.
February.
Item 24.
May I please, your lordship, regarding this matter, another similar matter is pending, lordship.
The matter is pending.
Lordship, let the both the matter come together, lordship.
At the request of the concept of the petitioner list along with number,
A Sharma.
another matter.
And
Details.
4749, 2024. 4749.
The petition number 4749 of 2023 after the
49 of 2024.
24, lordship.
whatever the details.
Supplementary list, item 32.
Wait, please, your lordship. Your lordship, the present writ appeal has been filed challenging the order dated 13/12/2024. It's a present case as such, it relates to frequent transfer. Otherwise, I would not have actually troubled your lordship because transfer, I bow down, your lordship.
Yeah, why you should not trouble the courts?
Your lordship, otherwise law is settled, I believe.
Approach the court, you should trouble.
Yes, your lordship. The other, otherwise, I wouldn't have troubled your lordship because I believe the law is settled with regards to transfer, but not with regards to premature and frequent transfer.
The premature and frequent transfer, what do you mean by how many, you are subjected to transfer, how many times?
Twice in this year.
Only, so it's a frequent transfer.
Frequent transfer.
Frequent. Twice frequent transfer.
Your lordship, that is because I've also made it a pleadings. This particular posting which I am undertaking right now is a command tenure posting, which is a prerequirement for my promotion to the next higher rank of superintendent
So
engineer.
that's why only the learned single judge has given a direction that consider his representation and address the grievance regarding this promotion and all. He has given granted your liberty.
Your lordship, that is there, but if I am post, because next year the DPC will sit.
How many days was granted for the learned single judge? Learned single judge has granted to decide your representation.
7 days, your lordship.
7 days.
7.
Whether it has been decided or you moved and representation, what happened to that?
I had filed a representation on 7th itself.
7th
of December. The transfer order is dated 6th of December. I was handed over this transfer order on 7th of December immediately, but since I am posted in near along
expeditiously within a period of 7 days from the date of receipt of the certified copy of this
certified
order.
copy of this order.
So you have filed this representation only on 7th.
No. This representation, yes, I had filed on 7th and it was submitted on Monday. That is Monday, December 9th, your lordship.
December 9th.
December 9th. Your lordship, the issue is such. Now, if I am posted out, your lordship, the only issue is, your lordship, premature transfer without any reasons. Just
show us the law that reasons are to be shown.
Yes, your lordship. Your lordship. If I may place the judgment of B. Vardhan Rao versus the state of Karnataka. And I may take your lordship to para 5 and 6, your lordship. And what EP Royappa, because B. Vardhan Rao quoted EP Royappa. Now, if I may take your lordship to paragraph number 5 at the bottom.
Yes.
It is an accepted principle. I'll start from there. Quoting EP Royappa. It is an accepted principle that in public service, transfer is an incidence of service. It is also an implied condition of service, and appointing authority has a wide discretion in the matter. The government is the best judge to decide how to distribute and utilize the services of its employees. However, this power must be exercised honestly, bona fide, and reasonably. It should be exercised in public interest. If the exercise of power is based on external considerations, or for achieving an alien purpose or an oblique motive, it would amount to malified and colorable exercise of power. Frequent transfers, I like lay stress on this particular line. Frequent transfers without sufficient reasons to justify such transfers cannot but be held as malified.
Transfers,
Frequent transfers.
frequent transfers.
Transfers, Your Lordship.
So
I was
You have been transferred only once,
twice, Your Lordship.
twice when?
I joined on 13th of February in Project Brahmang.
So it,
On 8th of April, I was transferred out from Brahmang.
have you opposed that why you have been posted in 13th of January?
No,
You are not agreed by that.
I did not oppose to the 8th April transfer because it was a command posting. After I met the respond number 2. Respond number 2, I made a specific reading to that effect. I met the respond number 2. He gave an assurance that I will not be disturbed because next year I'll be considered for promotion and this 2-year requirement is necessary for being considered for the post of superintendent engineer.
Okay. Yes,
Your Lordship. That is the difficulty.
yes.
And there in the Supreme Court has say in this particular paragraph that without reasons,
So there is no, without sufficient, where is they said, disclose the reasons. The authority is not obliged to disclose the reason to each and every employee that we are transferring you for that purpose. And so many words are there. If the exercise is based on extraneous consideration or for achieving alien purpose or an oblique motive, it would amount to malafide. So what was this extraneous
that's what
consideration you have mentioned?
I don't know, Your Lordship.
Yeah, I didn't know then.
The transfer.
How to come with this finding that it is for the extraneous reasons?
Although Supreme Court observed that if it is not without any kind of reasons, that
Sir,
will be.
who will show to the Supreme Court that this is only for extraneous reasons? Who is going to demonstrate?
That is why it is presumed to be extraneous because they don't actually give the reasons, Your Lordship.
It's not a case of assumption and presumption.
Your Lordship, they have not given the reasons. The onus is on them to give the reasons, Your Lordship. Just by citing organizational interest will not do, Your Lordship.
Sorry, sir.
Your Lordship, I've been subjected to this particular transfer. Now I'll be losing out on my career prospects because next year.
That's why
I'll
the
be-
learned single judges ask them to address this issue which you are raising. That the transfer of yours would detrimental in the promotional avenues. They have already observed that.
Your Lordship, then the Lordship may direct them to pass a speaking order to that effect. That if suppose, and that to that effect that it will not affect my promotional chances, Your Lordship.
So you just do, we'll do one thing. Get that expeditiously and the petitioner should be granted promotion. Will also observe this, na? Will direct them to grant you promotion.
To ignore this particular criteria.
Acha, still, oh yes.
Lordship, that
Anything else? A particular pay scale applicable to so and so will grant all the reliefs. You just mentioned kya chahiye aap.
Your Lordship,
Otherwise-
there's
नहीं, आप
this-
बोलिए ना सर,
No,
मांगने
Your
में
Lordship,
कमी रखा
because-
है।
Otherwise, if he so
Why you are कंफ्यूज क्यों रहे मांगने में? मांगो तो सही आप।
Your Lordship, only this particular command
Sir,
criteria,
Lordship,
because they will insist, I
otherwise,
know.
if so he is conscious for the career Lordship, he was Lordship on deputation to Lordship NDR Lordship Chhattisgarh in 2012 Lordship. Deputation period was completed in 2015 Lordship.
Hmm.
And after that Lordship in 2016, we have issued a letter to the headquarters of Brahman to revert back Lordship. Instead of revert back, he filed a Lordship petition before the Honorable Chhattisgarh High Court Lordship. And
That was
Chhattisgarh High Court says that it was stayed till the returnable date. But the matter was disposed of in the January 2024. He was Lordship 2016 itself, he was Lordship in the Brahman headquarters Lordship. By the court's order, he was staying there Lordship almost 12 years.
That
Instead
happened,
of-
that
instead of
was
3 years,
not
Lordship.
one-sided case, Your
Instead
Lordship.
of
That
3
was
years,
not a
he has
one-sided
Lordship,
case.
if he is so concerned, he's
There are reasons.
there is that.
I will not
Otherwise,
comment on
Lordship,
that.
the persons who has replaced him, Lordship, he's from the Pune, he's already arrived at destination, Lordship. I have the Kagaz ke details.
Your Lordship, the only difficulty, Your
On
Lordship,
gift
here.
center, he was released, Lordship. He was reported on 14 itself, Lordship. And otherwise also, Lordship, the project where he was entrusted in national importance, the road construction, the China border. So, Lordship, my lord, may kindly tell us
Right.
that particular volume, Lordship, particular instruction, Lordship, that instruction. Lordship, my lord, may kindly tell us paragraph 4, Lordship. Everything is detailed.
Right
And
now,
is
I'm in the China border. The only thing after filing of this writ petition, Your Lordship, I came to know that the person who is relieving me, he is of the rank of assistant executive engineer. And for this command post, Your Lordship,
because I don't have that particular rules with me right now. For command post, a minimum rank of executive engineer has to be there.
Challenge is separately.
That is what, your lordship, I didn't have that particular material on at that time of filing, your lordship.
This writ petition is filed by, this writ appeal is filed by the petitioner being agreed with the order dated 12/12/2024 passed by the learned single judge in writ petition number 6675/2024, whereby the writ petition filed by the petitioner has been dismissed. The appellant has approached the writ court being agreed with the transfer order dated 6/12/2024, whereby he was transferred from 92 RCC/44 TF/BMK to headquarters CE in bracket P PSK. Yes, the learned single judge, after hearing the consent of the parties, has refused to interfere in the transfer order. While observing that the refused to interfere in the transfer order, probably because the appellant has failed to demonstrate that the transfer order, the impugned transfer order is in violation of transfer policy or suffering from malafide. It is the learned single judge has taken note of the argument raised on behalf of the appellant that the said transfer order would be detrimental to his promotional avenues because the appellant would not be able to serve as a commanding officer. What commanding officer? Commanding officer, experience of which is necessary for promotion on the next post. The learned single judge has granted liberty to the appellant to move a representation before the concerned authority in respect of future prospect of promotion with the direction to the respondents to dispose of the said representation expeditiously, preferably within a period of 7 days from the date of receipt of the certified copy of the order. Having heard the learned concern for the parties, we don't find any illegality or infirmity in the impugned order passed by the learned single judge, hence no case for interference is made out. The writ appeal is therefore dismissed. Or it is expected that the respondents shall decide the representation filed on behalf of the petitioner, appellant, if not decided till date, expeditiously within a period of 7 days, 7 days from today, by a speaking order.
Paso barometer 5.
Yes, item number 5. For that driver's name, transport inspector. None present. Just after list in the month of February.
Obvious, my lord.
None present even in second round.
Obvious, lord.
Yes.
Item 18.
The notice was issued, the interim is continued, my lord, till today.
When dispose of this petition by observing that with this observation of the order, direction of the learned single judge
My lord.
of making this payment to you of rupees 10 lakhs will will not be given effect to. However, the learned single judge may decide them in case on
No objection, my lord. No objection that. My lord, if continue, my lord.
It goes in our favor. If the
Yeah.
matter goes in our favor, then the learned single judge can take it fall on that.
Actually, the learned single judge is supposed to
That
pass
part
an order.
Because since the stay order is there, till the final decision
No,
of the,
we'll make it clear that it's only.
till the final decision of the honor.
The learned single judge, what I found in paragraph, one of the paragraph which was stated, is because of the RBI circular. That's why.
Whatever it may be, it's a finding, and
Yes.
ultimately, if the learned single judge again comes to this, that there is a fault on the part of this bank, certainly they can issue a direction. Okay. The learned single judge, while taking into consideration the grievance raised by the private respondent in the writ petition regarding a fraudulent transaction resulted into siphoning of pensionary benefits of the respondents amounting to rupees 10,67,600 has issued certain directions to the has observed that the SBI, the appellant bank, is also not at fault because it appears that the appellant, that the private respondent was subject to cheating on account of some fraudulent transaction. However, has directed the SBI, appellant bank, to credit the amount so cheated after making necessary deductions in the account of the private respondent. It is noticed that the writ petition is still pending, and as an interim, the learned single judges directed the appellant to credit the amount in the account of the private respondent after making necessary deductions. Aggrieved by the same, the respondent, the appellant bank has approached this court, raising a grievance that once the learned single judge has found that the bank is not at fault, then the direction given to the bank to credit the amount in the account of the petition, account of the private respondent is not justified. It was the concern of the bank. It is the concern of the bank that it may open the floodgates wherein many of the customers who have lost money on account of fraudulent transaction due to their negligence may approach the courts for the similar reliefs. Full stop. Today, learned concept of the parties are in agreement that the so far as regarding the direction given by the learned single judge to credit the amount so cheated in the account of the private respondent, comma, of course, after making necessary, of course, after making not comma, of course, after making necessary reductions may be kept in abeyance. And the learned single judge be requested to decide the writ petition preferred on behalf of the private respondent on its own merit. Full stop. In view of the submissions made by the concept of the respective parties, we dispose of this writ appeal only dispose of this appeal, writ appeal, while interfering with the direction of the learned single judge of issuing direction to the appellant bank to credit the amount in the bank account of the petitioner in para number 26 of the impugned order. However, we request the learned single judge to dispose of the writ petition filed on behalf of the private respondents on its own merit.
Regarding the amount, Your Lordship, if the single judge is directed not to pay, then that may have a implication in the order next direction.
Till the pendency of the writ petition.
That.
Till the
Till
pendency.
the pendency.
Yes.
For hearing, item 26.
Lordship, the central excise appeal. A substantial question was framed by this court on 4/10/19, Lordship. While preparing the appeal, Lordship, I have noticed that minor correction needs to be made. Perhaps in the substantial question before the court adjudicates this petition, Lordship, because the question states that the Senware credit availed under the exemption notification. Senware credit is usually.
The exemption notification dated 25/4/2007 and 27/3/2008 can be disallowed and recovered from an assessee on the ground that the exemption was availed in the subsequent month.
The Lordship will note that Senware credit is not availed under any exemption notification. It is availed under Senware credit rules, Lordship.
Okay.
So only that part, if your Lordship may correct, subsequently it may be heard and decided, Lordship.
Then do one thing, we move an appropriate application, will amend the question of law
Lordship.
and supply my copy of the Lordship. Just after giving the petition. Move that.
Item 27.
My Lordship. Lordship, last week, Lordship has heard this matter length. The issue is only the query of the Honorable Court that whether possession of the land in question, whether the appellants are in possession, whether there
You
is.
raised this question that only mutation
Yes,
where
yes,
the possession.
yes,
Ah,
Lordship.
yeah,
Just recollect this.
yeah.
So now, Lordship, we have to check out the records and then found that from the initial prior, before the revenue court, we have asserted that we are in possession. And also asserted that we have a residential building over the land in question. This is one part. Another issue, my Lord, may take into consideration, this is a humble request, that our possession and mutation that flow from our sale deeds. Now the issue is that without the cancellation of the sale deed, whether the consequential part of the mutation order can be set aside. This is an issue.
That is,
This
the
is an
basis
issue.
of, basis
Yes,
of this,
yes, yes.
basis of mutation in your favor itself is
That-
illegal, then why not?
That is an issue, my lord.
That has already been resolved by the Honorable Supreme Court up to even Supreme Court. That is the initial, whatever the order on the basis of which some right is extended to you. If that is void or illegal, then the subsequent, all the, even this registration part will not come.
Therefore, the lordship, my lord's query was that whether we are in possession of the land in question. We are specifically pleaded before the revenue court as well as the board of revenue that we have a residential building, and not only that, my lord. Not only that. I'm sorry. And for information, my lord, I'm just placing before this honorable court that after the mutation and thereafter, the land in question was also sell it out to third parties also. There is subsequent sales.
Whatever it may be,
Oh, yes.
then they'll come before this court if they are aggrieved.
So there was
You address on your point only.
Yes,
How this,
but
your
I'm just-
mutation is justified.
I'm just placing my lord.
This, your mutation is justified when the person who has sold you himself has no title over the land. How your mutation is justified, sir?
Lordship, I can kindly take a note, I'm humbly submit, that as per 122 of the land manual of our state, if the person in his possession and the partners showing their readiness to transfer it by incorporating a note in the chita, the land may be transferred, which in our case.
How can it?
So that
The only question is the person to whom you have purchased, whether he has a title over the land or not. That was the only, a person cannot transfer a title
Correct,
which he himself is having.
Now, Manohar
Better
Ali,
than the title than he himself is having.
my vendor, he's got the title on the basis of an oral gift. That is our case. And lordship is
That has not been proved.
in Muslim law, the oral transfer is valid. Lordship is also aware.
The question, so where you have proved that the oral transfer was valid.
And more importantly, my lord, the appellant before the revenue court, he's not recorded. The respondent number 3, his hard name was not recorded. The respondent number 3, hard name was not recorded in the revenue records. And other partners were not the made part. In the appeal also.
So, where is that, these persons who are seeking cancellation of this mutation
My lord.
are not in possession, where is that assertion? Where is your contention in the pleadings?
Lordship.
Where is that?
The lordship will find at para 7, page 120. The initial written statement that is not in record because initial written statement in the revenue code. The Board of Revenue, our appeal in para 7, we have specifically.
Sir, before the court batao, the
Yes.
initial, before the initial court.
Yes, yes.
You have raised this question
Yes,
that
yes.
they are not in possession. I am in the
Yes, yes.
possession and therefore this application is not maintainable.
Yes, yes.
As per rule 41 or whatever the
Not,
rule.
not rule 41 mentioned, but we have specific para 8, my lord. Para 8. Para 8 of last page.
Never purchased the land, which is the discussion of the- What is the finding of the learned Singh, the trial court?
So far, that is interesting. So far, the question of the possession, there was no finding in the revenue code, the Board of Revenue, as well as the learned Singh agent.
You will consider.
Sorry.
After being vacation.
Lordship.
My lord,
my lord, my only submission with this regard is that, my lord, if Feruses for a second page 94 of the order passed by the Board of Revenue, the Board of Revenue has gone to each and every aspect in detail while passing the order. And the learned single judge, while dismissing the petition, has also stated the 226 petition has certain limitation with regard to scrutiny power. So there must be some employee error in page. My lord.
Which is that item?
Item 30.
Yes.
Grateful, my lord.
May urgency.
No, urgency is not there. In fact, by the last order, when about 7 months back, your lordship admitting, after admitting the appeal, directed that will be listed in the usual course. It has come up for hearing. I do not know how.
Oh, Lord.
I'm ready otherwise.
Urgency is that they did a judgment to pay out the benefit.
After view, after view.
Yeah.